Good afternoon, everyone, and welcome to the IP Key webinar on trade secrets. This is Corey Marshall coming to you from Southeast Asia, and I will be moderating this afternoon's webinar. To start off our webinar, I would like to call on our project leader, Mr. Tiago Guerrero, to deliver his opening remarks. Tiago, please.
Thank you very much, Corey, and good afternoon, everyone. Good morning, the ones connecting from Europe. 1 year ago, we thought that the challenges resulting from the pandemic would be over soon. We were hopeful, but we also have adapted. 1 year on, we have adapted, we continue to work and meet virtually, and we are still hopeful that the situation will improve soon. In the meantime, we continue our collaboration to enhance our global IP system and make it more responsive and relevant to any environment. That the IP system will continue to be affected by the global challenges we face, but as we adapt, so does the IP landscape. This year, we wanted to start with an intellectual property right that is not as well known as patents or trademarks, but most certainly not less important, trade secrets. So it is my pleasure to welcome you all to the first activity of IPKey Southeast Asia in 2021, a webinar on trade secrets. The IPKey Southeast Asia organized this webinar in collaboration with the Southeast Asia IPSME Helpdesk, one of our important partners in the region. We are joined this afternoon by two experts, one from the UIPO, Mrs. Giulia Predonzani, and one from Southeast Asia, Mrs. Triana, and I thank them both for joining us virtually. Finally, I would like to express my appreciation to all the webinar participants this afternoon for taking the time to listen to the webinar, and I hope that at some point in the near future I will be able to meet you in person. I would just like to also apologize in advance, as we are having some technical issues in our headquarters in Alicante. So I apologize in advance if any technical incidents happen during the webinar. Hopefully it will run very smoothly. Thank you very much. Back to you, Corey.
Thank you very much, Tiago. So as Tiago mentioned, this is our first webinar for the year, and we're hoping that our succeeding webinars will be successful. So participants may send the questions via chat at any time. At the end of each presentation, I will read one or maybe two questions, and after the third presentation, I will read all the questions that are sent by the participants. So without further ado, our first speaker is Ms. Giulia Predonzani, legal specialist from the International Cooperation and Legal Affairs Department of the EU IPO. As part of her responsibilities, Giulia represents the office before the Court of Justice of the European Union. Giulia has a master's degree in European, International, and Comparative Law and is fluent in Italian, her mother tongue, English, and French, and she is also proficient in German and Dutch, along with other languages she understands. Giulia, you have the floor, please.
Thank you very much, Corey, for this lovely presentation, and thank you, Tiago, for having opened the floor this morning. It is indeed my pleasure to have you here all with me today, and I hope that this is just the first of many webinars on trade secrets, and that the next ones will be in person, whether here under the sun of Alicante or in Southeast Asia with you. So without further ado, let's dive into today's topic. Today's topic is about trade secrets. And as you probably already know, trade secrets and confidential business information are critically important to the growth, competitiveness, and innovative performance of businesses. In the current globalized market, intangible assets are capable of providing a competitive advantage to all sorts of companies. However, when we think about how to protect innovation and how to secure a competitive advantage, as Tiago already mentioned, what comes to mind are usually other intellectual property rights, patents, copyright, trademarks, or designs, but not necessarily, we do not think about trade secrets. Nonetheless, where innovation does not fulfill the requirements of patentability, trade secrets do become a pivotal tool for companies to protect their business knowledge. My presentation today is divided into two main parts. The first one being meant to set up the context, the meaning, and the framework of the protection of trade secrets in the EU. Intellectual property and complementary rights play an important role in the innovation process, which is defined as a process that goes from the conception of an idea to the launch of a product or process on the market. This process, as you may see from this slide, involves different phases. But where do trade secrets play a major role? I would say that they do play a major role during the first phase of the innovation process, that is the acquisition and development of technology in order to increase competitiveness. But what are trade secrets? I mean, I believe we do all have a very good idea of what is a secret. Secret hideout, secret bank account, a secret crash. But what is a trade secret? In the next slide, I'm giving you here some examples of trade secrets in the sense that their existence is known, but not their content. Let's think about the Coca-Cola formula, which was created back in 1886. It is worth noting that the Coca-Cola recipe has so far been a secret for over 100 years. Coca-Cola never released its original recipe, but in fact, even though some have maybe tried and some have maybe succeeded in replying the exact same recipe, for marketing purpose mostly, or for other reasons that are to us unknown, the Coca-Cola recipe still remains a trade secret. What about Google? Everyone knows that Google uses an algorithm that ranks websites based on many different factors. However, no one, or at least not many people, know what is the exact algorithm used for the Google search engine. And you probably know in Thailand, the Mekong recipe for the first domestically produced Thai spirit, which was produced in 1941, molasses, rice, herbs and spices, and caramel in order to achieve its distinctive golden color. But how? How much? What is the exact combination? I'm sure that the inventors of such beverage are keeping their recipe well hidden. And Chef Jack Lee, he certainly knows about trade secrets when it came developing his $100 egg roll made of lobster tail, king crab, caviar, and gold leaf. Broadly speaking, a trade secret is a piece of valuable information which is treated as confidential and which provides the owner with a competitive advantage. All sorts of information, such as technical or commercial information, can be a trade secret. It can be strategic, long-term knowledge, or more short-lived. It could be positive information, such as the good practice, or even negative information, errors which are not meant to be made again. Almost any sort of information may qualify as trade secret as long as it fulfills the basic requirements that we have outlined before, i.e. of being valuable, potentially or really, treated as confidential, and could provide the owner with a competitive advantage. In this slide, you may see an illustration of all information which can be considered trade secrets, but it is by no means an exhaustive list. The information protected through a trade secret can be strategic and protected for decades, such as the Coca-Cola recipe I mentioned before, or a chemical compound, or more short-lived, such as the name, the appearance, the price, the launch date of a new product, or the offer in a bidding procedure. Trade secrets are property rights and can be assigned or licensed to other persons. The holder of a trade secret has the right to authorize a third party to access and use the trade secret information. However, due to the secret nature of trade secret information, it is not always easy for others to determine whether the information concerned meets the conditions for trade secrets protection. Therefore, compared with a patent, it is more difficult to transfer and license confidential information and solve disputes which may arise. Since a potential licensee needs to access the trade secret information in order to assess its value or utility, a non-disclosure or confidentiality agreement needs to be signed between the potential licensor and licensee. Further, in order to maintain the secrecy of trade secret information, a trade secret licensor should require a licensee to take reasonable steps to keep that information secret. So when it comes to trade secrets, we have already understood that might be some advantages in making reference to the protection which is offered under this intellectual property right, but also some disadvantages. But as a more general statement, considering the broad scope of trade secrets, pretty much all businesses do have trade secrets. Apart from the economic aspects, trade secrets are important due to a number of advantages. Trade secrets are easy to obtain. There is no requirement of registration and no examination process is involved. And because there is no need for compliance with formalities, trade secrets have immediate effect and are quick to obtain. They are flexible as they may evolve automatically throughout the years. Let's go back to our initial example, the Google algorithm. This algorithm is ever-changing and it is constantly adapted. But provided that all these changes remain secret, they will automatically benefit from trade secret protection. Trade secret protection is broad, as it can cover a wide range of information and may very well cover an invention which is not eligible for patent protection. Moreover, and as long as kept secret, a trade secret protection might be indefinite without the need of a formal renewal or paying any renewal costs. These are only some of the potentially benefits of trade secrets, which make trade secrets innovation friendly and a sort of do-it-yourself right. Having looked at the benefits of trade secrets, we also have already identified differences to other intellectual property rights. There are, however, a number of further significant differences which I would like to highlight. Probably the most significant one is that trade secrets, unlike patents, for instance, do not provide exclusivity to its owner. Trade secrets do not prevent others from copying or using the same solutions. Reverse engineering is entirely lawful. Trade secrets are only legally protected in instances where someone has obtained the confidential information by illegitimate means, whereas other intellectual property rights are mainly protected by means of a registration process. With trade secret, there is, of course, the risk of disclosure, which, if it happens, swipes away the value of the trade secrets and their associated advantages. Trade secrets are also more difficult to enforce than other intellectual property rights, in particular registered ones. Its scope of protection varies significantly from country to country and is generally perceived as to be weak. So when it comes about the framework of trade secret protection, a multi-layered legal framework is set in order to help undertakings protect trade secrets on an international, European, as well as national scale. On an international level, we have to think about the international standards for protecting trade secrets were established as part of a TRIPS agreement, i.e., the Agreement on Trade-Related Aspects of Intellectual Property Rights, which is an international legal agreement between all the member nations of the World Trade Organization. The TRIPS is not self-executing, even though binding for each member of the World Trade Organization, and the provided definition of trade secrets is applicable in member states only where national law adopted such definition or case law has made explicit reference to such definition. On a European level, and with a view to harmonize trade secret protection throughout the Union, as we can see in the next slide, this trade secret protection has been inserted in a harmonized instrument, which is the Trade Secret Directive adopted in 2016. This directive is in line with the TRIPS agreement and sets out minimum criteria for protection against unlawful acquisition, disclosure, and unlawful use of trade secrets. The directive also harmonizes the definition of trade secrets, which is in line with Article 39 of the TRIPS. The directive harmonizes as well different forms of misappropriation, unlawful acquisition, unlawful use, unlawful disclosure. Moreover, the directive clarifies expressly what is not perceived as an infringement of trade secrets, for instance, reverse engineering or independent discoveries. The Trade Secret Directive is meant to harmonize the trade secret protection throughout the member states. As regards legal measures, the Trade Secrets Directive only harmonizes civil measures, such as, for example, stopping unlawful use, unlawful disclosure of trade secrets, the removal of goods which have been manufactured on the basis of a trade secret infringement, preliminary measures, and damages. The Trade Secrets Directive, however, does not establish any criminal sanction. As the directive sets out only minimum criteria for the protection of trade secrets, member states remain free to provide protection within their national legislation, which goes beyond the scope of the Trade Secrets Directive. As we can see from the next slide, on the national level, trade secrets are protected through different pieces of national civil or criminal legislation. Some countries have dedicated acts on trade secrets, while others regulate protection of trade secrets in a manner which is similar to traditional intellectual property rights. Other countries have trade secrets provision in legislation aimed, for instance, at unfair competition, labor law, or criminal law, just to mention a few. When dealing with trade secrets, the main purpose of the member states' legislators has been to protect business secrets, but also to address other interests, such as openness and freedom of information. The balance between these interests relies on the one hand in providing the protection that the company needs in order to be able to continue their research and development without the risk of misappropriation of valuable innovative knowledge, and on the other hand, in securing interest in a transparent society with a great exchange of information. The OIPO monitors the implementation of the Trade Secret Directive. In fact, the Trade Secret Directive provides in its Article 18, paragraph 1, that the UIPO shall prepare an initial report on litigation trends regarding the unlawful acquisition, use, or disclosure of trade secrets pursuant to the application of this directive. The UIPO Observatory has drafted a report in 2018, which is called the Baseline of Trade Secrets Litigation in the EU, which I am referring to in this slide, and I invite you to take a closer look if you are interested in the topic. Because in this report, the UIPO has examined the current level of trade secrets litigation, as well as the profiles of parties involved and the courts dealing with trade secret matters. This study aimed to establish a benchmark, and especially at capturing the impact of Trade Secrets Directive on legal disputes before civil and criminal courts concerning the misappropriation of trade secrets. The study covered all 27 EU member states and the United Kingdom and contains a mapping of the national legal systems for the protection of trade secrets, competent courts, procedures in place, including remedies against unlawful acquisition, use, or disclosure of trade secrets. This study has shown that there is a high degree of heterogeneity between single member states legislation on the protection against this unlawful acquisition, use, or disclosure of trade secrets. The main differences that emerged from the study attain to elements such as the presence or absence of a national definition of trade secrets, the scope of protection, and the sources of law. Also, the availability of case law on trade secrets considerably diverges across the EU, thus mirroring differences in how effective the existing means of protection and the remedies available to businesses are perceived in the different member states. As regards the first difference among national legal systems, which is referable to the lack or existence of a precise definition of trade secret, which has made it difficult for certain companies to prove that their information or data did in fact qualify as trade secret and needed therefore to be protected, is in several member states provided not as a proper definition, but in several instruments of civil or criminal law. The only two countries where a definition of trade secret is set forth by the Industrial Property Code are Italy and Portugal. There are a number of member states where the definition of trade secrets is provided otherwise in one or more legislative acts. Another member states, on the other hand, that has a sui generis law on trade secrets is Sweden. The scope of trade secrets protection also varies across member states. Even if not provided with an ad hoc legislation, Italy and Portugal expressly include trade secrets in their industrial property codes, classifying them as intellectual property rights. In France, on the other hand, the intellectual property code addresses a specific protection, but only for manufacturing secrets. The scope of protection is thus quite restricted, since it does not include protection for commercial secrets. In the remaining member states, general legislation applies. Even though the scope of legal protection may diverge throughout Europe, it has to be said that protection against the disclosure of trade secrets by employee is provided for in all countries, at least in the form of a general confidentiality duty for the employee during an existing employment relationship. The enforceability of non-compete provisions, which are instead applicable after the termination of employment, may, on the other hand, vary substantially among jurisdictions. The common law countries, such as Ireland as well as the United Kingdom, have based trade secrets protection on case law's interpretation of the breach of confidence. Trade secrets are also addressed through tort law in Belgium, France, Luxembourg, and the Netherlands. Malta relies exclusively on contract law, while the legal system in Cyprus provides for criminal remedies and civil liability only in case of breach of contract. Undertakings are reluctant to start litigation proceedings on trade secrets violation, mainly because of the following reasons. it is very hard to demonstrate misused information, that the misused information qualifies as a trade secret. The protection of trade secrets is scattered among different sources of law with unclear or insufficient regulation. It is difficult to secure evidence and high costs related in order to secure such evidence. And sometimes in certain member states, there is an absence of appropriate procedural measures in order to guarantee confidentiality during litigation proceedings. Since providing evidence for the existence of a trade secret violation is rather difficult, rights holders adopt a wide range of precautionary practical measures to protect trade secrets. If you are an SME or another business, I invite you to do as well the same. Because as I have stated in the beginning, a trade secret only provides a competitive advantage and is protected as long as it remains secret. It is therefore crucial for businesses to take appropriate measures to ensure that trade secrets do remain, in fact, secret. This can be done through different means, maybe mainly consisting of non-disclosure agreements, non-use agreements, license and know-how agreements for the commercial transfer, and contract for the lawful exploitation of technology, non-competing clauses in employment and consultancy agreements, and other technical security measures. Such preventive instruments are crucial for the enforcement of trade secrets, since member states' courts often require to grant protection and to issue the requested remedies, that practical steps have been taken by the businesses to keep the relevant information secret. However, undertakings should consider trade secrets as a piece of a larger approach and as being part of an overall strategy of protecting and exploiting their innovation and intellectual property rights. The interdependence of such rights, in other words, their use together with other intellectual property rights, can assist right holders in obtaining effective protection, especially in countries where there is a low level of specific protection for trade secrets. Given the differences between member states' legislation, even the ECJ has mentioned trade secrets protection in some of its case law. Here I recall only few judgments where confidentiality of trade secret has been quoted by the ECJ. In a case of 2018, the ECJ has recalled that the protection of business secrets is a general principle of EU law. In the case of Parifarma against the European Medical Agency, the General Court has indicated that even the work of assembling public information could constitute trade secrets, but it must still be shown that this assembling of public information provides in itself not only a commercial value, but a competitive advantage. And an added criteria that the case law of the ECJ has added in order for information to be considered a secret is linked to his time, in the sense that in this judgment, Evonik Degussa against Commission, the ECJ has found that information which was a secret or confidential, but which is at least 5 years old, must, as a rule, on account of the passage of time, be considered historical and therefore as having lost its secret or confidential nature, unless the party relying on that nature shows that despite its age, that information still constitutes an essential element of the commercial position or the commercial position of third interested parties. Those considerations, which give rise to a rebuttable presumption, are valid both in the context of a request for confidential treatment, irrespective of the parties intervening in actions before the EU courts, and in the context of requests of confidentiality with a view of the publication of, for instance, a Commission decision on a decision finding an infringement on competition law. Another interesting order of 2010, Telefónica and Telefónica de España against Commission, draws the attention to the fact that a distinction needs to be made between, on the one hand, information which is secret by nature, as trade secrets, as, for instance, commercial, competition, financial, or accounting information, and information which is confidential because it's the internal and specifically linked to the company itself. And on the other hand, information which might be secret or confidential because a reason exists that the applicant must put forward. So as we can see, even though the general protection of trade secrets may vary across member states, each court somehow has put forward different mechanisms in order for businesses to protect such trade secrets. And trade secrets do offer a very interesting and valuable opportunity to protect business and strategical information that could not otherwise be protected under another intellectual property right. And as far as I'm concerned, I will come back to you later in the second part of this, rather the third part of this webinar today, with a few examples and a case study. But now, if I may, I'll give back the floor to Corey to move on with Evie's part.
Thank you very much, Giulia. But before we move on to Evie, I have one question for you. So can an entity's financial information be protected as trade secrets, as a trade secret?
Yes, of course. Financial information can be considered as trade secret, provided that they fulfill the three main criteria. Is this something which is potentially valuable? So it has an impact in the sense that it provides a competitive advantage for the business itself, in the sense of the medium-sized enterprise that I want to bid in a special call for tender, and these are my information that I want to use for this specific call for tender. So it needs to have a potential or actual value. The second requirement is that this information is secret, in the sense that it cannot be easily discoverable or easily made available. And the third information is that the company itself has taken all the relevant measures in order to keep this information secret. Because if I can find all this financial information already on the website of the company, then of course they are not eligible for trade secrets protection.
Thank you very much, Giulia. So I have a couple more questions, but I will read them at the end of your second presentation. And we will now move on to Evie. Thank you very much once again, Giulia.
My pleasure.
So our next speaker is Ms. Evie Triana. Salamat sore, Evie. External expert of the Southeast Asia IP SME Helpdesk, our partner in this afternoon's webinar. So Evie is a partner at, I hope I pronounce this correctly, Suryomurcito and Company, a member firm of Rouse Network.
Right, it's Suryomurcito actually.
Suryomurcito.
Yes.
Apologies.
That's okay.
So Evie handles various intellectual property matters for both local and international clients. And of course, she's admitted to practice law in Indonesia. Evie, you have the floor, please.
Thank you, Corey, for the introductions. It's a pleasure for me to be the speaker in this webinar. So I'm going to start with my presentation. Before that, just a quick info on the Southeast Asia IP SME Help Desk. The services from Inquiry Helpline, where you can send any IP questions, training workshops and webinars, which is tailored to the needs of SMEs, publications for various IP topics and guides, as well as learning tools or modules are provided free of charge for EU SMEs and intermediaries. I'm going to start my presentations. As you can see from the slide, these are the agendas that I'm going to present today. So I will discuss about IP and trade secrets, the practical examples of trade secrets, commercial or key factors of trade secret protection, the difference between trade secrets and confidential information, how are you going to manage the trade secrets, contract enforcement of trade secrets, and last but not least, cases related to trade secrets. So before we start, what is a trade secret? As Ms. Giulia already mentioned previously, I just want to make sure that we all know that trade secrets are one of the intellectual property rights that protect confidential information, which may be sold or licensed. The idea is keeping a valuable information secret and prevent competitors from learning about and using it, and thereby you can enjoy competitive advantage in the marketplace. In general, to qualify as a trade secret, the information must be commercially valuable because it is a secret, and then it has to be known to a limited group of people or persons, and it will be subject to reasonable steps taken by the rightful owner of the information to keep it a secret, including the use of confidentiality agreements for business partners and employees. So the unauthorized acquisition, use, or disclosure of such secret information in a manner contrary to honest commercial practices by others is regarded as an unfair practice and a violation to the trademark protection. There are two types of IP, for instance, registered and unregistered. The registered IP are trademarks, patents, designs that need to be registered with the national IP offices, while the unregistered IP such as copyright, trade secrets, unfair competitions are protected automatically, meaning no procedural formalities for their protection. But this automatic protection for unregistered rights are subject to special rules. Like I mentioned previously, for trade secret, the rules are it has to be commercially valuable, known to only limited group of persons or people, and there are reasonable steps taken from the trade secret holder to keep the information secrets. There are two legal regime exist. For civil law or trade secrets, for example, Indonesia, we call it trade secrets, and then there is for common law or confidential information, for example, in Singapore. In today's world, the trade secrets are becoming one of the most important IP assets. For example, Google search algorithms, Facebook's data, Spotify music selections algorithms, Amazon shopping's prompts or reference to the other what the other customer bought, etc., or specific procedures that are implemented in the software or website. There has to be a trade secret in every patent and design ever. For instance, your research, your methods, etc., which I will further explain it in the next slide. The following are the definition by WIPO on trade secrets. For services, it can be sales methods, special technique on how you do your sales, your distribution method, consumer profiles, your strategies on advising to your list of suppliers and clients. And for industrial businesses, there are manufacturing processes, technical know-how, not the general technical know-how that's already been around in public, business operation manuals, recipe, Coca-Cola for instance, or any special techniques for development of a product or services. In this slide, I'm going to explain about the key issues for trade secret. Commercially valuable, I mentioned that earlier. And as you might already know, the competitive edge of many business is based on keeping the information confidential. There is a difference between trade secrets and the general know-how, which is the level of secrecy, not generally known among or easily accessible to persons within the same circles, but that normally deals with this kind of information. And then I also mentioned as well that it is known to a limited group of persons. It really does not matter if you think that the information is a secret, but it has to be factual that it is a secret. That means you have to be able to prove it when there is a dispute. Of course, a secret itself means that it must not be known to your competitors or other public sources, such as any information you can find at the library, online database, trade journals, patent informations, etc. And then reasonable steps to be taken by the rightful holder. There are steps that you have to be taken to protect the secrecy. For instance, reasonable security procedures, NDAs, so that the information cannot be easily obtained. Most of the registered IP has a time limit, 20 years for patents, 10 years for trademark, 10 years for design. But for trade secrets, it can last forever. Coca-Cola recipe is more than 100 years. But first thing you need to do for your trade secret is that you have to define it first. What is your trade secret? Describe it and then lock it in a safe or password protected file. The precise conditions for protection of a trade secret may vary from country to country. The key is looking at where the secret is kept or deployed or used and where any breach has taken place. Use that country's law. So as mentioned in the previous slides, there are two legal regimes exist. For Indonesia, there is a specific trade secrets law, which defines trade secrets as business or technical information that is not known by the public and has economic value in business. There is civil and criminal remedies exist, and they are easily transferable under contract. For Malaysia, it's using common law of confidence to protect confidential information. Equity-based rules comes from the civil case law. Confidential information is a non-public information, which is why it's kept confidential. So protection is against unauthorized use, which causes harm, and the remedy is through civil courts only. For example, the Songsan Palm Oil Mill versus Jiang Kim Luang in 2011. So this confidential information is not easily transferable assets. So the key difference between trade secret law and the confidential information is a better portability of trade secrets through an assignment or license, etc. In the table on the right-hand side, you can see which rules or laws for trade secrets for each country in Southeast Asia. Okay, in this slide, I will tell you on how to manage your trade secrets. Since trade secrets is unregistered right, therefore it is invisible with no form of proof. And to prove them, you must be able to show various steps as follows. The trade secrets must be managed to be protected. So you have to have someone or a small limited group of people in charge to keep the trade secrets. Then you have to identify, catalog, list them, and then keep them updated. You can use a document or spreadsheets and mark it as confidential. Keep it a secret and lock it up in the business, either physically or password protected file. Make sure you have a good IT security for confidential data protection. Separate drives with no access to junior staff. Limit employees' access to data, firewalls, antivirus, software, encryptions, etc. Check if the physical security is effective. A lot of companies restrict access to manufacturing, technical, R&D, and other sensitive areas, or lock access either by fingerprints, face recognition, or anything else. Do not forget to train your employees on trade secret issues at least once a year. Inform them not to copy documents or move it somewhere. Clear communications and repetitions to the employees can help a lot and make known that the disclosure of a trade secret may result in termination and or legal action. Always involve HR in entry and exit interviews. This way, you can always make sure to remind staff to protect and not disclose any trade secrets your business have. It is important that your employment contract contains trade secret clauses that are obliging your employees to protect and not disclose any trade secret. You have to always maintain records of and document all these steps and keep them updated. An accurate record keeping is very important. One of the reasonable steps taken to protect your trade secrets is by contractual means. So you have to keep in mind that contracts and NDAs are essential. Please make sure that you always use NDA or confidentiality agreements before you disclose any sensitive information relates to your trade secret. Before you enter into an agreement or contract with a third party in which your trade secrets are used, you must have adequate clauses for protection. Again, employee agreements must contain trade secrets protection clauses, what they can do, what they cannot do. For civil jurisdictions, you can use assignment on trade secret since it is transferable to correct the owning entity, especially to external contractors which your company use. The contracts must be local to the country in question. The precise condition for protection of trade secret may vary. So do not forget to always follow the usual contract rules, choice of law, dispute resolution. You may want to consider arbitration for trade secret if the local courts are inexperienced with this sort of cases. And you can also register the relevant contracts, licenses, for example. The trade secret enforcement. So how do you enforce trade secrets? The unauthorized use or improper acquired information or disclosed trade secrets by anyone other than the owner is regarded as infringement. If you know that your trade secret is improperly acquired, used, or disclosed by someone, check the contract. A well-drafted contract can set out a solution, termination, and dispute resolution. You can also go for civil legal action, where the usual goal is a civil court injunction to stop the misuse or disclosure, as well as damages. In some countries, trade secret theft is criminal. Criminal cases are investigated by the police and cases brought to the prosecutor by the prosecutor. IP dispute can be investigated by the IP office. Legal warning letters, settlements, and negotiation are common resolution tools, especially if the trade secret owner does not want to use the court rule. Most common trade secrets dispute are ex-employees. It can be disgruntled employees stealing ideas to work for competitors or start new businesses. Some sensitive industries suffer from cyber theft, for example, network attack. In the next two slides are some of the case examples on trade secrets. In this slide are some examples on trade secret cases in Southeast Asia. There is a case between iAdmin Singapore versus Hong Ying Ting, where two individuals set up a competing business while still employed by iAdmin. The court ordered an Anton Pillar order, which revealed that the individuals took and used confidential materials relating to software, and they even deleted the files during the raid while the Anton Pillar order was being executed. And then there is another one for Singapore. In 2010, several relationship managers of a bank in Singapore left in a group to a rival bank. Prior leaving to the previous bank, they emailed the data from the bank's computer system to their own personal email accounts. They also accessed printed confidential company data. These employees were subsequently charged in a Singapore court for unauthorized access of confidential client data. In Indonesia, PT Basuki Indonesia filed a claim in 2008 against a local division of Hitachi Constructions and several individuals for trade secret infringement. The issue related to competing boiler constructions. In 2017, the Court of Appeal set damages of $750,000 against Hitachi Constructions, which is amounting about 50% of the lost profits during the period of theft. The Supreme Court, under the case 3305, awarded $84,000 for material and immaterial loss. Before the decision at the Supreme Court, PT Basuki claims was dismissed by Bekasi District Court. The judges reasoned that the commercial court, rather than the district court, ought to have jurisdictions over the case because the case concerned intellectual property. And the commercial court had previously heard a related industrial design case between the same parties. However, the Supreme Court upheld the plaintiff's appeals against the case dismissal. So the case was sent back to the Bekasi District Court to be retried. This case was another example on trade secrets from the United States. So the first case in the United States of America versus United Microelectronics Corporation, the U.S. government indicted a Taiwanese company, United Microelectronics Corporation, UMC, and others of selling trade secrets. In addition, the government filed a civil lawsuit seeking an injunctions against the defendant, including UMC. The government's requested injunction seeks to stop transfer of stolen trade secrets and to keep some of the defendants from exporting products manufactured by UMC. and another company that were created using the trade secrets of Micron. Micron is the only US-based company that manufactures drum technology, which the Chinese government did not possess until recently. UMC pleaded guilty and was fined $60 million for IP theft. And then there is another one, Google's Waymo self-driving car subsidiary sued a former Google employee, Anthony Lewandowski, for secretly downloading 14,000 LiDAR data files from Google's hardware systems before resigning. And then he launched a self-driving truck startup called Otto, which Uber acquired in August 2016. For this case, Google won about $245 million. I think with this last case of trade secret, I'm ending my presentations today. Back to you, Corey.
Thank you very much, Evie. So I have one question for you before we move back to Giulia. How do you know when to keep a piece of information or an innovation, an IP, as a trade secret rather than file a patent for the know-how?
Oh, I see. Okay. So there are many reasons a patent is better for PR, investors, enforcement, etc. Trade secrets itself are often used where a patent is not possible due to patentability. For example, data, business methods, computer algorithm, like I mentioned earlier, or where the element of the technology is public. So when a reverse engineering can be easily carried out, it will be beneficial to the company to register it as a patent. But when a reverse engineering is impossible to do, and the business established and maintain the secrecy over that information, it can be considered as a trade secret.
Thank you.
You're welcome.
So we will, I will invite you again after Giulia's second presentation. Thank you very much,
Okay.
Evie.
You're welcome.
So before I turn over the floor back to Giulia, I just would like to remind the participants that we have a feedback form at the end of the webinar. So we would appreciate it if you would fill out the form to help us improve future webinars. Giulia, I turn over the floor back to you.
Thank you, Corey. And if I can complete the answer that Evie has just provided, and when a patent is preferable rather than a trade secret, I would also underline that one does not exclude the other, in the sense that when it comes to the stage of research and development, we can start by having trade secrets, and later on, when I have the final patentable discovery or innovation, then I can proceed to a patent. So in this sense, both IP rights can be combined, which is good to know. And it's also good to know that for startups which do not necessarily have the financial means for having a patent registration, which can be costly, trade secrets can also be a valuable asset to protect their innovation process. But in order to explain better what would be the best solution, we have prepared today for you some further examples and some case studies. As for the first example that I have here to propose you, it's something to underline that trade secrets encompass both technical information, such as information concerning manufacturing processes, experimental research data, software algorithms, and commercial information, such as distribution methods, list of suppliers and clients, and advertising strategy. A trade secret may be also made up of a combination of elements, each of which by itself is in the public domain, but where the combination, which is kept secret, provides a competitive advantage, then it can be protected by trade secret. Other examples of information, and here I confirm, as compared to the question which was asked before, that we can protect with trade secrets financial information. Another, unfortunately, very speaking field in which trade secrets do play an enormous role is vaccine development, as well as the creation of diagnostics and treatment from information like genomic data, biological resources, manufacturing know-how, and negative information like research that ends. Trade secrets do pervade the battle against COVID-19. In that sense, finding COVID vaccines is no different from any other innovation scheme. with trade secrecy operating alongside and in conjunction with patent, copyrights, and trademark. However, in the COVID space, there are a few significant differences. At their center is the basic issue of whether the sharing of certain trade secret information would be a net benefit for the world, resulting in a more rapid development and expanded supply capacity and more affordable vaccines, treatments, and diagnostics. There are good reasons to think that it would be in the world's best interest to share information that would otherwise be considered trade secrets because of three public health priorities: speed, adequacy of supply, and affordability. On a more cheerful note, as another example of trade secret, we can think about the next slide, natural rubber. Natural rubber is an important agricultural product. As of the mid-2000s, there were 15 major companies processing and selling concentrated rubber latex in Thailand. Some companies studied the benefits of being able to recover rubber from the sludge that builds in the nooks and crannies of processing equipment during latex production, or that which sinks to the bottom of latex pools, which is normally ignored. This sludge rubber recovery technology brought several IP challenges. First, the process was straightforward and easy to replicate. Second, there was no way to detect whether recovered rubber was derived from this process or from any other source, so enforcement of trade secrets was in fact difficult. Finally, since the major benefit of the technology involving using existing chemicals and manufacturing process flows, potential customers and competitors already possessed a great deal of relevant knowledge. Taking this into consideration, protecting the know-how of the process via a trade secret was essential. Moreover, because an important benefit of the technology is to save costs by utilizing existing waste stream, the formulation can be adjusted to the unique requirements of each factory. And in that sense, flexibility can only be guaranteed by the use of trade secrets. What elements of a social media account could constitute trade secrets? In base of economic terms, the value of individual social media interactions seems to be negligible. After all, what is a post but a few bits of data sent through the internet? But in a world where social media's influence can mean the difference between a lucrative sale and another fruitless cold call, social media accounts at companies have taken on added significance. The questions are multiple. Does customer information qualify as a trade secret in the sense that if it's shared via a social media, yes or no? If it's shared, the answer should be no, because of course it's not secret anymore. However, the moment that is of commercial value, and provided that the social media owner took reasonable measures to protect it, then it could be considered a trade secret. And another further question, can a company cash in on or claim ownership of an employee's social media account? And if so, what does that mean for workers who are increasingly posting on Twitter, Facebook, Google, Instagram during work hours? So while these tools can be a great way to spread the word about a company's products or services, they can also compromise proprietary information, including trade secrets. And in order to safeguard a company's trade secret, it is important, as Evie was saying, to create policies for employees that clearly detail the company's expectations as regards the use of social media. Include social media provisions in employment-related contracts, such as non-disclosure and non-compete agreement, or add filters in the use of websites that employees can use when they are at work. Investigate a social media provider before using it for marketing purposes, in the sense that once company has to check what controls are in place and if there is protection against hacking or if there are other measures to protect against other security threats. And as a last advice, stay on your toes. Social media continues to evolve and will likely pose even more and more challenges for the intellectual property world in the future. Another very speaking example are the WD-40 product. It is said that the product name is stemming from the fact that it took scientists 40 attempts to come up with a water displacement formula for a rust prevention solvent and degreaser. Not only the actual formula is the trade secret, but also what went wrong in the 39 failed attempts to create the formula, which is an example on how also negative information may still qualify as trade secret. In order to put into effective practice and court cases, the information that we have talked about today, I have selected for you a few case studies in the following slides. This case study, if you are interested in having a closer look at them, and if you're interested in undergo further investigation into other cases across the EU member states, I refer to you to this document that I mentioned, the first part of my presentation, the baseline of EU litigation when it comes to trade secrets, which was established by the Observatory of the EU IPO in 2018. The first case study that I would like to present to you is the case study coming from Spain. In this case, it was the Provincial Court of Madrid, which has resolved an appeal having its origin in a dispute between a company and another company and a former employee of the first company. The first company filed a claim of misappropriation of business secrets, commercial know-how, and illicit acquisition of information related to employees and information related to customers and conduct contrary to good faith. According to the company, a former employee of hers left the company, started his own company in the same business sector of the company itself, and hired a person who held the position of commercial director in the first company and was a partner in such a company. After having hired this person, the newly founded company began as well to somehow take advantage of the former's company confidential commercial information, especially those regarding employees and customers. As a result, probable result, because it was not proven in the end, 8 other employees left the first company and were hired by the new company. The Provincial Court of Madrid's rulings rejected, however, the claimant's motivations, stating inter alia that customer acquisition could not be considered disloyal in itself, and it was not demonstrated that the workers' recruiting affected a very important part of the staff or somehow hindered the company's performance in the market. It was also not proven that customer information, such as customer lists, were used by the competing company, and workers' information did not constitute privileged information, and there was no evidence of their use beyond the worker's identity. The supposed commercial know-how was not a business secret since it lacked competitive value, and there was no evidence that measures were adopted to ensure the preservation of confidentiality. So once again, we find the 3 main characteristics in order for trade secrets to be protected: the need to be valuable, to have a potential or real competitive edge, to have been the object of protective measures, and to not have been easily discoverable. But to this end, these actions may also not prevent a normal competitor to make use of knowledge which is not considered as trade secrets or could not be considered as trade secrets to start a new business and in the same field of activity, provided that there's no infringement or unlawful use or unlawful acquisition of trade secrets information. Another case study coming from France this time. Also here, there is a case that is opposing a company against its employee. In this case, the court ordered inter alia the cessation of the use of any product developed using the claimant's trade secrets and also of any license agreement, exclusive or non-exclusive, in relation to such products. The French court established a penalty of 100,000 euros per day for each future violation of the order by the defendant. Moreover, the court also imposed the destruction of all documents illicitly acquired to disclose the company's trade secrets. Finally, the publication of extracts of the judgment in 10 professional journals, French and foreign, at the expense of the liable defendants was also ordered. A third case study comes from my own country, Italy. In this case, the Court of Milan was required to issue a preliminary injunction and seizure related to an assumed misappropriation of trade secrets and know-how connected to bone cements and biomaterials used in dental care. The defendants were accused of the production, marketing, and distribution of products resulting from the misappropriation of the claimant's trade secrets and know-how, as well as of infringing a prior German injunction decision issued against the defendant. So not only there was a problem with trade secrets protection, but also cross-border trade secrets protection, which had to be enforced at different national level. The court's decision in Milan relied on the principle of the territoriality, according to which the effectiveness of untitled immaterial rights, such as trade secrets, is limited to a territorial extent. due to the lack of a homogeneous jurisdiction and regulation of trade secrets at the EU level, the court decision is directly enforceable in another member state only if and as long as the acting judge bases its jurisdiction also regarding the facts of the infringement which took place in the other member state, which was not the case in the case at hand. In conclusion, there was one multi-step conduct of which the German judge examined just one phase. The Court of Milan was consequently entitled to conduct a separate and autonomous assessment of the conduct that occurred in Italy and rejected the claimant's request due to the lack of requirements necessary to issue the preliminary measures which were requested. A fourth and final case study comes from the United Kingdom. In this case, a Danish company producing insecticidal fabric initiated legal proceedings in Denmark, the United Kingdom, and France for trade secrets violation by two former employees and a former consultant. Once again, we see that the majority of litigation starts between company and former employees. Such trade secrets were contained in a specific database, which was called FENS, and the defendants had established a new company and had started to produce competing products using the information which was contained in the FENS database. The two former employees' contracts contained provisions requiring them to respect the confidentiality of the company's trade secrets, and therefore they have been sued by such company in Denmark. The Danish company also sued them in the United Kingdom, and the English High Court found that the information on the FENS database could qualify as trade secrets and ordered an injunction against the defendants for the misappropriation thereof. However, the High Court did not order an injunction for the subsequent products of the defendants, since they represented an advanced version, which was also the result of independent work, and an injunction was considered unequal as a measure. In this sense, this judgment, which came up to the Supreme Court, is particularly interesting because thrives to strike a balance between protection of trade secrets and innovation. The Supreme Court held that, particularly in a modern economy, the law has to maintain a realistic and fair balance between effectively protecting trade secrets and other intellectual property rights, and not unreasonable inhibit competition in the marketplace. The importance of the economic prosperity of the country in terms of research and development in the commercial world self-evident, and the protection of intellectual property, including trade secret, is one of the vital contributions of the law to that end. On the other hand, the law should not discourage former employees from benefiting society and advancing themselves by imposing unfair potential difficulties on their honest attempts to compete with their former employers. It's all for me for the time being, and I look forward to many questions coming from the floor.
Thank you very much, Giulia. We have a couple of questions from the floor, and the first one is a follow-up question to the earlier one. So if an innovation meets the threshold of patentability, is it advisable to keep it as a trade secret or protect it as a patent? Or can you protect the innovation as both a trade secret and as a patent?
I think there's not a win-win solution in the sense that it all depends on the strategy of the company itself. If I decide to keep my innovation under trade secrets protection, of course, I don't have to pay for fees. Of course, I can develop further without having to register a new patent. Of course, it will be more my right to decide when I want to patent. But at the same time, I have less protection because in the absence of a patent, I know that in case of unlawful disclosure or lawful disclosure in the sense of reverse engineering, I would have lost my trade secret. And the risk would be that the company who in the end has done the reverse engineering patented the innovation before me when I was actually the initial owner of this innovation. So in terms of what is best, it all depends on a company. If I am on a company with great financial assets, and I would like to make sure that I'm the sole user for the next 20 years of my innovation, I will probably, of course, decide to go for a patent, knowing perfectly well, however, that after 20 years, then my patent has no value anymore, and that every year I will have to pay a registration fee. If I'm a startup and I'm still developing and I don't have a final product, but I'm convinced that my product will be successful, why not start with a trade secret and try to keep it as secret as possible with all due methods and measures that we have talked about today?
Thank you. So may I invite Evie to join us for the other remaining questions? Okay, so you both mentioned earlier that enforcement is rather challenging. So isn't enforcement of trade secrets, isn't this a disincentive for creators or generators of IP to protect their right as a trade secret if enforcement is very difficult? Maybe both of you can answer the question. Evie first.
Enforcement is difficult, but we have to think about that enforcement is the worst case scenario. That means that something went wrong. That means that I did not take my due diligence in order to protect my trade secret. And it is difficult because it's difficult in terms of burden of proof. How can I effectively control that an employee has stolen my trade secret? How can I effectively prove that my competitor has somehow hacked my system, etc., etc.? So of course, in this sense, it is more difficult due to the heavy burden that a litigation proceeding may involve. And also because somehow the line is not very defined, as it is, on the other hand, with registered IP rights, such as patents or copyrights or trademarks and design. But of course, this difficulty in enforceability gives, on the other hand, and this is the other side of the coin, a positive side, a lot more of flexibility, and the fact of being able to keep updated my trade secrets as long as it evolves is something that no other IP rights can offer. It's maybe worth the risk if I'm planning to have an algorithm such as Google, for instance, that I know that I will constantly adapt, or if I have, again, if I'm an SME and I don't have the final product, or I have not yet defined which kind of product I'm going to commercialize or put on the market, and I can start by having heavy package and structure and resources to protect my innovation process and see at a later stage if it's worth patenting or not.
Thank you, Giulia. So I will maybe repeat or rephrase the question also for Evie. So isn't the difficulty of enforcing a trade secret, doesn't it pose a challenge or a disincentive to owners? So instead of protecting the right as a trade secret, they would either not protect it or they would probably file a patent if assuming it meets the patentability threshold. But isn't the difficulty in enforcement a disincentive?
Yes, it is like Giulia said, it's very difficult to enforce. You have to, the burden itself has to be in the trade secret holder. So you have to make sure that, yes, there is a breach or there is a theft of your trade secrets. And it's, for Indonesia itself, it's very difficult, especially for, there are a lot of, in Indonesia itself, we still have a problem with corruption. So it's kind of like better to keep it to yourself. I mean, like Giulia said, if you think that it's more beneficial to have it as a trade secret, then have it as a trade secret. But if you think that it can be beneficial for patents, it will be easier to have it enforced as the registered IP.
Thank you very much. So are there any exceptions in case, let's say, part of the trade secret was used for non-commercial purposes? So I suppose if somebody makes use of part of it and doesn't probably ask for permission, so will that fall as an exception to the trade secrets protection? This was a question sent by message.
If I understand correctly, the question is, so if I am using a trade secret for non-commercial purposes, will it still be considered an infringement of the trade secret?
Yes.
It will be, as long as I put at risk its confidentiality, because if I'm using it as academic research and I'm bound, for instance, I'm a law student and I would like to know how this company has worked in order to submit a tender, which has won. It was a very lucrative tender. And of course, I am not interested in using those data for me to bid in the tender. I'm just a law student who is interested in knowing how this tender was awarded and which were the criteria and what are the specifications of a company. So of course, in this sense, I'm not infringing anything, but in order, probably, if I'm the company who has won the contract, in order for giving my data, I would have probably put an NDE written an NDE with a law student, making sure that, I don't know, my name is hidden from his final thesis, or that the current value are not precise, but are between a bracket and another, so that they're not very specific. So there's no infringement as long as I do, the infringement is not linked in the use of the information for commercial or competitive purposes, or in order for me to benefit for having a competitive advantage. The infringement is related to disclosure or misuse of the information that I was given access to by legitimate means in this case. Whereas if I have had access by illegitimate means, no matter what the purpose is, and no matter what I do with this information, that it will always be a breach of trade secret protection.
Thank you. So next question for Evie. So what if someone has a trade secret concerning boiling coffee at a temperature of 250 degrees Celsius? I suppose it's something that tastes good. So the person then applies for patent protection for boiling coffee at a temperature of 200 to 300 degrees Celsius. So would that person be able to claim as trade secret the exact temperature, since the exact temperature is still confidential?
My personal opinion, if you already filed a patent for that specific 200 to 300 Celsius, so it's not trade secret anymore. It's already been out, and I mean, probably what he can do is that the research, how he gets that specific, the boiling point of 200 and 300, the research can goes under trade secrets, but the patents itself, when he already patented for 200 and 300, so it's already out there, so it cannot be trade secrets. Giulia, can you please correct me if I'm wrong?
No, I think you are right. I share your views.
Okay, thank you. And next question for Giulia. So what are your personal thoughts on the possibility of vaccines or patents for vaccines being expropriated by member states of the EU or by the EU itself in the context of the COVID-19 pandemic? I'm not sure if you would want to answer the question.
In order to expropriate, one has to have a legal basis, which I'm not sure we can find out of a general principle of general public health, but we are not there. I think we still are, or we want to be, in a very democratic EU environment where everybody is, we have defined roles of decision takers and legislators. So I don't see it happening. I see hopefully an agreement which has already taken place, but and in terms of expropriation of patent, and also how would the EU patent as a legal entity, that will also require some careful thought, to which extent, who will be the owner, who will be the controller, who will pay the fee. So I think that it's something that it's not in the public domain for the time being to reason as a private entity when it comes to COVID vaccines, not right now anyway. We will see what the future brings, and hopefully it will bring a lot of good vaccines for everybody.
Thank you very much. That was actually the last question, but I think Tiago wanted to say something about it. So on that note, I would like to call on Tiago.
Yes, Cory,
give a comment and post to close.
Thank you so much for that. But I think indeed, Giulia more or less reply to that. The situation, or this last question, it is, let's say, a little bit out of the scope of our webinar today on trade secrets specifically. And there are some positions already from the EU on this take of the vaccines. There is on the WTO, there have been discussions among the member states. So I think it is better to wait for the developments of the WTO in order to see what will be the official position from the EU also on that side. And we, at least at the UIPO, we don't interfere, as you are a technical agency, so we don't interfere in those discussions. But though, thank you very much for the question. And with this, I would like indeed to just 1 minute of just some closing remarks from my side. I hope everyone found this webinar useful and enlightening, as I certainly did. And I would like to thank all of you for your assistance throughout the webinar. I would like to once again thank our speakers, and hopefully this time I'll get the names right. So Mrs. Giulia Predonzani and Mrs. Triana, thank you so much for being with us today and for the excellent presentations. And I want also to extend our appreciation to the SEA, IPS, and Helpdesk, and lastly to all the team that make this webinar possible. You can also, everyone can check our IPKey Southeast Asia website to see our next events and our next webinars. And I certainly hope to see you all very soon.